5, 4, 3, 2, 1, start. It was argued generally before the division bench that the learned single judge could not have set aside the selection on the basis of the reports of the scrutiny committee, which were admittedly the sample and partial scrutiny. Even during the arguments before the division bench, no opportunity was given to the counsel for the appellants to examine the materials on record and also to take the copies thereof, enabling them to support the selection of the candidates. Regarding the aspect of non-joining of proper parties, the division bench noted the general notice directed to be issued through publication by the single judge by his order dated 6/10/2005. The division bench further noted in para 18 that the notice so published was vague as it did not mention the case numbers, districts, selection centers, etc. It also noted the arguments of the appellants that though applications were made by the selected candidates for impleadment in the related writ proceedings and though a direction was prayed for supply of copies of the writ petition, the learned single judge did not pass any order and the copies of the writ petition became available to the appellants only on 23/11/2005 and they had to file their reply affidavits even without knowing the contents of the writ petition. The division bench also noted the further arguments that the writ petitions themselves were vaguely drafted. It was, therefore, argued that the selected candidates were denied a fair and reasonable opportunity of projecting their cases, resulting in violation of principles of natural justice. It was pointed out that even at the time of fixing the writ petition for hearing on 8/11/2005, the selected candidates were, admittedly, not impleaded as parties and the proceedings, therefore, suffered from serious procedural lapse. It was further argued that the learned single judge also fell in error in directing the selected candidates to file the appropriate affidavits even without either impleading them or ensuring that the copies of the writ petitions were served on them. It was also pointed out that the reports prepared by amicus curiae and the 3 judicial officers on the basis of the sample scrutiny made by them were not made available to the selected candidates and, therefore, the learned single judge erred entirely in relying on those scrutiny reports. Per contra, the submissions made on behalf of the appellants were opposed by the writ petitioners and it was reiterated that no prejudice was caused to the selected candidates and no such grievance was made before the learned single judge. It was reiterated that the selection of any particular individual or individuals was not impugned but the whole selection process was found faulty. The division bench noted its own earlier order dated 4/10/2005 whereby the earlier appeals were disposed of and a further direction was given that the parties were at liberty to take recourse to provisions of Order 1 Rule 10 as also the other provisions in the CPC.